Welcome everyone to this webinar on Adtech and cookies, what to expect in 2021, and practical insights into recent regulatory and legislative developments, and also presentation on the Adtech ecosystem. We are delighted to welcome you today. This webinar will be recorded and will be shared with you after today's webinar. If you wish to ask any questions, you may do so by asking your questions in the question box, and we will be reviewing and answering those questions at the end of this presentation. So after a quick introduction, we will have one of our speakers help you to understand the ad technology and the ad tech world, how it functions, and especially what are some of the upcoming developments in the ad world. We will also give you an overview of regulatory guidance and the latest developments, and then we will finish with a Q&A session. So today I'm delighted to introduce our distinguished speakers. First of all, Sixtine Crozet, who is an associate at Phil Fisher's privacy team in our Brussels office. Also, Jo Delannoy, who is a partner and BD director at Programmads, a company that assists other companies with their online ad campaigns. And I'm delighted to welcome Jo, who is replacing Gaëtan Godard, who unfortunately could not make it today. I am Olivier Proust, partner at Phil Fisher in our privacy team. So without further ado, just to give you a little bit of background on cookies and the EU regulation. This is an area that has been developing for a number of years now, and there have been quite a few developments in recent months. But if we just go back a few years, well, the legislation on cookies and online tracking dates back to the e-privacy directive. Now, this e-privacy directive is part of a European package of legislation that was initially adopted in 2002, the purpose of which is to regulate electronic communications within the EU, and the e-privacy directive is one of those directives that deals specifically with the protection of privacy in the area of electronic communications. So the provisions on cookies and online tracking can be found under Article 5.3 of the e-privacy directive, even though this article does not specifically use the term cookies. Following the adoption of that directive in 2002, it was amended a first time in 2009. And as we will see in a minute, there is another proposal for a new legislation to replace the current e-privacy directive. But essentially, this Article 5.3 provides for the consent principle that any online tracking or access to information on the user's device requires prior consent, unless there are certain exceptions that can apply, and we'll get back to those in a minute. And so users have to be notified, have to be informed, and have to give their consent whenever a company is accessing or dropping information on their device. More recently, what has changed, obviously, is the definition of consent, which is found in another legislation that we are all familiar with, the GDPR, which came into force in 2018. And as you probably know, the definition of consent has changed and now has to comply with some stricter rules, in particular, the fact that it has to be unambiguous and that you need a clear affirmative action of the user to express consent. Since then, we've also seen some case law from the Court of Justice of the EU on cookies, in particular the Planet 49 ruling, which was one of the very first court decisions dealing with consent in the context of cookies, and which in particular provided for the fact that pre-ticked boxes did not meet the requirements of the GDPR consent, and therefore pre-ticked boxes was not deemed as a valid consent mechanism. And of course, we cannot speak about cookies without mentioning the very vast amount of guidance, regulatory guidance. Here we've only mentioned the guidance at an European level, so the one that was adopted by the European Data Protection Board, or previously the Article 29 Working Party. We're not going to go through all of those in details, but just to highlight that they do touch upon cookies, and particularly the guidelines on consent are interested to understand how the definition of consent and how the rules on consent apply to cookies. So here, what we've provided here is an overview, a timeline of the proposed e-privacy regulation. Now, I mentioned that we are still currently under the regime of the e-privacy directive, but as you've all heard, I'm sure, the European Commission made this proposal to replace the e-privacy directive with a regulation. For those who are maybe not familiar with European legislation, the regulation applies directly or has a direct effect within EU member states, as opposed to a directive which is implemented, and therefore there may be variances in how a directive is implemented under national law. That is actually one of the reasons why the European Commission made this proposal for a regulation. The goal is to harmonize the regime that applies to cookies across the EU. Now, when you look at this timeline, you can see that the European Commission's proposal dates back to the 10th of January 2017. That was 4 years ago. So 4 years since the European Commission made its proposal. And although the European Parliament was very quick in adopting its position on the text in the same year, in 2017, since then the text has been stuck at the level of the Council, the Council of the European Union, which represents the member states, and only recently, a few weeks ago, the Council also adopted its position. So as you can see here, the text has been going from has moved along in the hands of the different EU presidencies, and you probably know that we have a rotating system of presidencies for the European Union. So currently we are under the presidency of Portugal, but that presidency ends at the end of June this year and will be followed by the presidency of Slovenia. So if Portugal is not able to get the text adopted, which in fact seems quite unlikely, then this will move on to Slovenia. Once the text is adopted, then there will be a 2-year transition period before it is enforced. So just to sort of narrow down and focus a little bit on what the e-privacy regulation, or at least the draft version of this text, mentions with respect to cookies. This is very much where we stand today, and what the 3 European institutions are going to be discussing as part of the trilogues. So the trilogues in the European legislative procedure is where the European Commission, the Parliament, and the Council of EU ministers gathers, and they review the different versions of the text and adopt a final version. So as you can see here, the text has evolved since the European Commission's initial proposal. The principles remain the same, that you need a consent with 2 exceptions that I mentioned earlier, namely that you don't need consent if the cookies are used for the purpose of transmitting a communication, or to provide a service at the request of the user. I think what's interesting to highlight is, and that is actually going to be the focus of the Trilogue discussions, are how those exceptions are broadened in scope to address and include other exceptions. Now, you can see that the European Commission had already included web audience measuring as a possible exception. This was adopted in the Parliament's version and also in the Council's version. So I think it's pretty safe to say that most likely audience measurement is going to be kept in the final version as one of the exceptions. But as you can see, both the Parliament and the Council also made proposals for other exceptions. The Parliament in particular proposed exceptions where cookies are used for security updates or in the employment context, and the Council broadened that even more to include the use of cookies for fraud prevention purposes, software updates, and other purposes that are compatible with the initial purpose for which the cookies are used. So the discussions as part of these trilogues are really going to focus here on those exceptions, and it's going to be interesting to see in the final text what are the exceptions that are kept in the end. So with that, I close this brief introduction, and I will pass it on to Jo, who is going to give you a bit of an overview of the Adtech sector and how it all works. So Jo, the floor is yours.
Yeah, thanks a lot, Olivier, and hi everyone. I'm excited to be able to address you all today in this webinar organized by Fieldfisher. Thanks a lot for inviting us also. So the marketing industry loves data, obviously, because it's the best way for us to effectively understand human beings and their needs. This also means that good marketing is based on trying to understand people, trying to understand their needs, and helping to fulfill those. Responsible marketing means fulfilling those needs in a way that is good for people. And the infrastructure of digital marketing, though, also known as Adtech, which I will come to also in my next slides, for decades has been based on serving people tiny invisible images, pixels called cookies that collect and share information about them. And these cookies, they tag your device with a unique identifier, and through an extremely complex landscape of systems, those identifiers, they get stitched together to attempt to build an addressable profile of you. In the following 15 minutes, I will be focusing on trying to provide you with a better understanding of how the Adtech ecosystem works through reliance on cookies. And I'll try to compare the cookie situation with a physical offline example. So imagine that you're opening a new wine store, a physical brick and mortar a wine store. And instead of having to build your own prospect and client information, you immediately would have access to a very detailed list of people's preferences, people that haven't even been in your store. You would immediately have detailed information and direct access to all people who like Merlot, Cabernet, or Syrah. And you would be able to directly contact people who regularly purchase wine in other stores. You would have access to lists of people who have bought cheese and bread, and they are now near your wine store. And people would only have to look at wine, and they would be on your direct contact list. Sounds quite easy, right? So it is actually a bit too easy. And this is what has been going on in the last in the digital advertising industry during the last decades. And as we move to the next slide, as a reminder, we need to distinguish two main types of cookies. And probably this will be repetition for some of you, maybe new for others, but we distinguish first and third party cookies. And from a technical perspective, there is no real difference between the two types of cookies. They both contain the same pieces of information and they can perform the same functions. The real difference between the types of cookies has to do with the context in which they are created and used. There are different benefits of creating first versus third-party cookies. So a first-party cookie is stored by the website that you are visiting directly. So they are allowing website owners to collect analytics data, to remember your language settings, to remember your shopping basket information, and to perform other useful functions that help provide a good user experience. And they are considered to be a good and an accepted type of cookies. On the other hand, we have third-party cookies, and they are created by a domain, a website, other than the one that you are visiting directly, hence the name third party. So this happens, for instance, because you have been exposed to an ad, and this ad has dropped a cookie on your machine. So they are used for cross-site tracking, retargeting, ad serving, and other functions. So you can go to the next slide, please. How people think about their data and privacy has fundamentally changed, and we've seen significant shifts happen in our industry because often users have lost trust in how businesses use their data. Their trust in digital marketing is declining, and consumers are also increasingly concerned by the way digital marketers use data. And this results, of course, in action. You all know better than me what's going on the regulation side of things, so I will not go into detail about that. But on the other hand, we see changes happening within browsers. And as the main gatekeepers of the web browsers are adding features to limit the use of cookies. And this is a movement which has been initiated by Apple within their web browser Safari, quickly followed by Mozilla with Firefox. And from 2019, they also started blocking third-party cookies because of the fact that they were losing market share to more privacy-centric browsers like Brave and like Safari. And as we can see on the next slide, in 2020, eventually the most popular browser in the world, Google Chrome, came with the announcement that they were going to depreciate also the third-party cookie within the following 2 years. And as you can see in this graph, with a global market share of 63%, the impact of Google Chrome on the fate of third-party cookies is massive. And this is the reason that you are hearing a lot lately about the cookieless world or cookieless advertising, this situation that we are entering now slowly but surely. So you can move to the next slide, please. So now, what is it about cookies that they have gotten such a bad name? Well, this is really linked to the principle known as cross-site tracking, for which third-party cookies are being used. And I like analogies with the physical world, like the wine store. So imagine the internet is a shopping mall, a huge shopping mall with all kinds of different stores and brands. And imagine you visit a store and you look at a certain brand, but you don't buy it. But you leave the store to visit other stores within the mall. And while you do, all of the brands of the stores that you previously visited are following you around as you go around the mall and looking over your shoulder at everything you do. The main purpose of third-party cookies is to recognize you as you are browsing the web. So this identification is very important, and this information is fed into Adtech platforms that can then serve you relevant ads based on your interest or your browsing history. So that brings me to Adtech, and you will see on the next slides what I mean by that. And disclaimer, I will not go into detail about all of those different technologies, but Adtech or ad technology is a term used to describe all of the different tools used to run, to deliver, to manage, and to optimize programmatic advertising campaigns. And programmatic means automated advertising campaigns using technology. So on the one side of the spectrum, we have a brand or an advertiser, also referred to as the buy side, and they want to reach a certain target audience to sell their products or their services to. On the other side, the side that we refer to as the sell side, there is a publisher that has an audience on their website or app, and they want to make money off of it, off of their website advertising space and also audiences. So you can move to the next slide, please. So why does digital marketing actually need this type of technology? Well, looking at digital advertising or even advertising in general, we can distinguish different eras. So it all started, for a brief history lesson, it started with the broadcast era. First of all, with offline marketing like TV, but from the 90s onwards, also digital. And it started off quite simple. You know, the ads that was used for a newspaper or for a magazine was also placed online. So the ad was placed on a publisher website, let's say the New York Times, and everyone that went onto that website got to see the same ad. But then along with the popularity of the internet, and the number of websites and also the number of internet users began to grow exponentially. And people also started to use various different devices to browse the web. Phones, tablets, watches, televisions, you name it. And this created a wealth of information stored in cookies. So this brought us into the precision era. And instead of having to select a certain publisher you wanted your ads to appear on, you could simply now show relevant ads to people wherever they were browsing based on this information stored in their cookies. And that's why ads technology emerged because this process became increasingly complicated for marketers and for agencies to decide which website to show an ad on which device, to make sure that the ad would appear to for the right person at the right time on the right device. So that's why Adtech emerged. So you can move to the next slide. So if we would compare digital advertising to a classic roadside billboard, the billboard itself would be the ad placements, which is the space on a website where an ad can be shown. The poster would be the ad itself, and Adtech would be the ladder and the glue necessary to put the ad where it needs to be. And as we can see on the next slide, ad technology sends the ads to the right users at the right time, but it also collects at the same time user information stored in cookies, often stored in cookies. The information which is collected, it can be about the delivery of the ads and the performance of the ads. You know, how many impressions did we measure, how many clicks did we have, but also information about the user. And as we move to the next slides, we can see that there are specific ad tech solutions which are being used to place ads on certain environments. An example is Facebook. If you want to advertise on Facebook, you need to go through the proprietary Adtech platform of Facebook. And on the next slide, we see that the ad tech industry today consists of thousands of companies. In 2020, this was more or less 8,000 companies. Fun fact: 1 in 5 did not exist 2 years ago. So it's a hugely growing market, and there are solutions specialized in advertising, in content, and in experience, in social media. But data is by far the fastest growing category. Up to 26% is about data, which makes sense because we are generating a ton of data. As we see on the next slide, the main goal of Adtech is to provide personalized experiences. When two people go to the same website, they will see different ads because of the information which is available in those Adtech platforms. On the next slide, we see that the reason that a lot of marketing teams and agencies are nervous about the cookieless reality is because of the fact that a lot of functionalities of cookies will break, and this will have an impact on their marketing campaigns. So here's a few of the most important functionalities of cookies, and I will maybe discuss a few of them. Of course, behavioral targeting and ad personalization. The fact that you see an ad that is personalized to your interests or to your needs. Retargeting means someone who went to a website, checked out a product, and afterwards an ad is being served to try and persuade you to continue your purchase. Zalando, for instance, is a very good example. You look at a pair of shoes, and those messages reappear to make sure that you finish your purchase. Will not be possible anymore because this is using third-party cookies to make sure that this ad can be sent to you when you are on other websites. Frequency capping. So, marketers want to limit the number of times that they show an ad to you because they want to, of course, avoid wasting too much advertising money. So frequency capping is setting a maximum of the number of times that one ad is shown to a specific user, and this will be very hard to track without third-party cookies. Ad measurement. Measurement is a very important part because marketing teams want to measure the effectiveness of their ads, and due to the fact that today, if you see an ad, you don't react immediately, but a few days later, you go directly to the website of the advertiser and you purchase something. This is tracked, but this is using also cookies to identify you because you were on the website or you saw an ad a few days ago and you didn't buy immediately. So these are a few examples of things that will become very difficult going forward. And as a last slide, I would suggest that we look again to the wine store, because for those people opening a wine store, as from next year, things will get a bit less easy, because instead of having direct access to people's profiles, they will need to start gathering this information themselves by engaging in conversations with their clients. If people give their permission, if people give their consent, of course. So this concludes. Hopefully, this gave you a better view on the use of cookies within Adtech, and then I suggest that we pass it on to 16.
Thank you, Jo. That was super interesting. And hello, everyone. So Olivier mentioned at the beginning briefly the roles that apply to cookies at EU level. And I'll be focusing on the roles that apply to cookies at member state level. And I will try to give you some tips to update and implement your cookie banner or CMP, your consent management platform on your website and on your app. And then I will briefly discuss enforcement and complaints. So if we go to the next slide, please. So as we saw earlier with Olivier, there's some guidance at EU level, but it's rather limited because it's not very practical. At member state level, it's quite the opposite, as you can see here. We have a lot of guidance under various names, so yeah, recommendations, guidelines, statements, notes, and so on. And here I set out a timeline with 8 important jurisdictions in the EU. As you can see, they have all been quite busy in the past few years since the entry into force of the GDPR, and they all have updated their guidelines. And the reason is what Olivier mentioned earlier, which is that with the GDPR, there's a new definition of consent, which is stricter because consent has to be unambiguous. And so these GPAs have drawn the consequence from this, and they also took into account the case law of the Court of Justice and the Planet 49 case in particular. So typically their previous guidance was much more lenient. Typically further browsing was considered valid consent. And also they had less requirements in terms of transparency and information that you had to provide to users. I'm not going to go into the nitty-gritty of the content of this guidance, but what we can say is that there's a fragmented approach. The content is not uniform, and so I will walk you through some key takeaways, and we can already identify some topics where all of these guidelines directly contradict. If we go to the next slide, please. Yeah, so analytics cookies is a prime example of the divergence that exists nowadays. I'm sure you're familiar with it. So typically analytics cookies can help you have some insights on how your website and app are being used. And from these insights, you can then make decisions on the way you organize content on your website. So it's very important, and your marketing and business teams routinely, if not daily, rely on such data. So here we can see that 3 authorities, so the Italian, the Dutch, and the French one, consider that you do not need consent for this type of cookies if you meet certain technical and specific conditions. Of course, these conditions vary depending on the 3 countries, but to reach this finding, they consider that this type of cookies fall into the broader category of strictly necessary cookies. And that's why you can drop this type of cookies as soon as users land on your page, provided that you meet the conditions, of course. But this analysis is not followed by the other DPAs, which strictly interpret the e-privacy directive and which consider that you need an opt-in from your users. And as Olivier mentioned before, now there's an explicit exemption in the 3 drafts of the e-privacy regulation about web audience measurement. So there will be a further legal development that will have to follow in the future. If we go to the next slide, please. So on the positive side, there is some common ground between authorities, and they, in particular, they stem from GDPR standards and the definition of consent. I'm sure you're aware with these basic requirements, but it's important to remind you of them. So consent needs to be an affirmative act, so it cannot be inferred from user action or user inaction. And in particular, at this stage, authorities consider that you cannot infer consent from the browser's confidentiality settings because it's not specific or informed enough. And authorities also consider that you cannot drop any non-essential cookies before you obtain user consent. So that's pretty clear now throughout Europe. And if we go to the next slide. Thanks. But then on the other hand, authorities are not, they have a fragmented approach in their practical recommendations on how to concretely obtain user consent. They agree that you need some kind of granular consent, so per cookie category. So you would need to ask users, for instance, to consent to advertising cookies, analytics cookies, social media cookies, and so on. That's clear. Some authorities consider that it's valid to ask user to consent to all these non-strictly necessary categories. So that's what we call a bundled consent. But there are certain conditions to be able to rely on bundled consent. You need to offer users a granular consent somewhere else. So typically on the second layer of your consent management platform, the CMP. And also what's also very important is linked to design. So it's not strictly legal, it's very factual. You need to offer users equally prominent options. That's what I included here on the first options. So you have an accept all button, a reject all button. They have the same size, the same font, the same color. And here we can say that it's not misleading, that you're not influencing or pressuring users into taking a particular course of action. But it's not a universal solution, and there are also some interesting alternatives that other authorities have offered. On the second option, the CNIL in France considers that it's not necessary to have a reject button. You can also replace this button by having a cross within the CMP to allow users to close the CMP, and this action would be considered as a refusal. Or you could tell them, if you click outside of the CMP, it means that you're rejecting cookies. So here you have to clearly inform users again how they can reject, not to mislead them again. Then a third option would be the Spanish one, which is more business friendly. According to them, you can just have an accept button and then a link to a more granular consent on the second layer, and you can obtain valid consent this way. Then if we go to the next slide, we can describe another thorny issue, which is transparency. How informed should users be, and how can consent be informed? So it's a difficult topic within organizations, because usually there's a heavy pushback from the business team and the marketing teams, because they want to keep the language as short as possible within your CMP, and you also want to be compliant. So here there's no uniform approach. Some DPAs, some authorities, they require you to have some kind of information within the first layer of information, so directly on your CMP. Then you would have additional information within the cookie notice, which is a second layer of information, we can say. So you have to navigate between these two layers of information. We can say that Germany and France have stricter requirements, and typically the information would be longer in these countries. We think that you should at least include within the first layer the following categories of information. First, you should say who the data controller is, so it's the website publisher. Then you should list exhaustively all the purposes for non-strictly necessary cookies. And then you should really clearly explain, as I said, how users can accept or reject cookies. You should also flag that you're relying on third-party cookie providers, which is most often the case, and you should link to the cookie notice. Then I should also mention that typically cookies involve the processing of personal data, so it triggers the application of the GDPR. So you would have to have a transparency notice, so website or app privacy policy. It's a best practice to differentiate between the cookie notice, which is meant to comply with the e-privacy directive, and a website privacy policy. So it's a good practice to have these two different documents in place. Then if we go to the next slide. Yeah, so with this in mind, and with all this complex, we can say, landscape, how can you comply with these rules? You may be an organization that is present in Europe, in different countries, and you want to comply with the rules, but it seems quite complex. So how can you roll out your CMP on your website or on your app? In the past few months and years, we've been assisting clients in taking three different approaches. The first approach would be the pan-EU approach. So you would have a single wording, a single CMP that you would roll out in all the countries in which you are present. So obviously it's less time and resource consuming, but then the drawback would be that you would have to come up with a compromise wording and a compromise way on how you collect consent online. And I should mention here that the guidance I described earlier, it's usually soft law, so it's not binding as such, but typically authorities will enforce the national cookie rules by relying on their own guidance, because it represents the way they interpret the law. And so they would more or less ignore how authorities, even neighboring authorities, have interpreted the same rules. So this approach carries some risk in terms of enforcement because you may be compliant in a country but not in another. So that would be, first option. A second option is the regionalized approach. It's pretty clear that we can divide the EU into two groups, at least, of authorities. Some of them are more lenient. They're more business friendly, for instance, in Spain. Also, in Italy, they updated their guidance just a few months back. So before they were more lenient. So you could take advantage of this flexibility and maximizing your consent rates on your website. And then the second group would be a more restrictive group with authorities that have stricter requirements. So in France and Germany, for instance, and here you should be you should try to be compliant because the enforcement risk is also higher. And then a third approach would be country per country. So obviously, it can be quite costly because you will have to analyze the content and the nitty-gritty of the guidelines in each jurisdiction. But then the advantage is that in terms of enforcement, it's less risky because you can really tailor your CMP to each jurisdiction. So unfortunately, there's no one-size-fits-all approach. It really much depends on your sector, your organization, your footprint in Europe, in which countries you are present, where you are established. And yeah, if you have only a corporate website, you're less likely to drop cookies, or if you operate in an e-commerce sector or another data-driven sector, then you would be much more reliant on cookies. So these are all factors that you should take into account when, strategically speaking, you would try to adopt the right approach. If we go to the next slide, please. So in any case, regardless of the approach that you adopt, we have set out here a few practical steps that you can take if you want to either update your current CMP or implement a new one. First, you should choose a CMP provider. So the bad news is that there's no officially endorsed CMP provider in the EU, and there are many competitors on the market. So it's difficult to choose, but here you should really analyze the content of their solution, whether it's compliant, how much flexibility you have in adjusting it to local requirements. Then another second important step is the classification of cookies. You need to scan your website and mobile app to check which trackers, in the large sense, not only cookies, but local storage, fingerprinting, etc., which trackers you're using. The goal here is to differentiate them depending on their purpose. So advertising cookies, social media cookies, analytics, and so on. And then depending on their purpose, you would differentiate the strictly necessary cookies that do not require user consent and the non-strictly necessary cookies that require consent. And here it's a difficult task because there's no uniformity again in the EU. There's no list of essential cookies, and there's definitely a gray zone for some cookies on which authorities do not agree, and so you would need to justify on a case-by-case basis where they're located. A third step would be to draft a wording on your CMP, first layer of information, second layer, and so on, and to make sure that consent is validly obtained, concretely speaking. You should also flag which third party you're using, and so for that, it's also linked to the cookie classification that we saw earlier. But then it's not the end of the story. Once your CMP goes live, you still need to check regularly and audit your website, because even if the CMP looks good and fully compliant, maybe there's a technical problem and some cookies are dropped automatically. And here it's very important to understand that it's very, very easy for anyone really to go on your website and check your cookie practices, to take screenshots, to download or use a software, free software, and check whether you're setting automatically cookies, and then if they're unhappy, they can just complain to the authority, or the authority can also carry out an online inspection without informing you while they're doing it. So it's super important to make sure that everything is working. If we go to the next slide, thank you. We can discuss the recent enforcement. So we have set out here the most significant enforcement action or decisions that we have picked up. So it's not exhaustive because, well, because of space constraints, but in particular in Spain, they had quite a number of low fines recently, so we have not included all of them. Once again, we can see that there's a fragmented approach, and authorities have adopted very different enforcement strategies. So if we take the example of France, because it's quite interesting and we can see a lot of French flags here. So they, as you may be aware, that they have fined Amazon and Google last December for breach of cookie rules. So to reach that finding, they found that there were 3 cookie violations. First, these entities were not properly informing users that cookies were being set, and they were not properly informing them about the purposes and also about the possibility to refuse cookies. So that was a first important information violation relating to transparency. Then a second violation was the lack of prior user consent for advertising cookies. So it means that these types of cookies were being automatically dropped on users' device without their consent. And then a third violation was that Google failed to take into account users' objection to cookies. So even though some of them objected to cookies, cookies were still being set. So this gave rise to significant fines, as you can see. And here I should mention that actually 15 days ago, the grace period just ended. So France is also and other authorities where there was a grace period, but Ireland also had one, which terminated a few months back. But so it means in France that the CNIL is ready to flex its enforcement muscles, and investigations are already on the way. It's quite interesting how they approached enforcement. In the past few months, they set up an online observatory in which, through which they monitored the most important websites. And then the CNIL proactively contacted this organization saying, we see that you're not fully compliant, please comply by the end of the grace period. It was not a formal investigation, but it was an interesting way of forcing compliance, let's say. So it's true that in France, enforcement is on the way, and the CNIL has some organizations on its radar, and cookies are one of the top 3 enforcement priorities for this year. But then if we take the example of a smaller country like Belgium, their approach is quite interesting in comparison. They struck early, we can say they sanctioned a small website in December 2019, Jubel, and they imposed what you would think is a small fine, which was 15,000 euros. But actually it amounted to 1% of their global turnover. So it's quite significant in terms of sanction. And then that same month, they also carried out a cookie sweep in which they analyzed the cookie practices of 20 different websites. And I should mention here that it was quite unusual because they updated their guidelines in April of the next year, so April 2020. So all this enforcement action took place before they even updated their guidance. So yeah, we can see that authorities have a different approach. Others are really trying to engage with the sector, such as the ICO with its investigation on Adtech. The CNIL also had many stakeholders meeting. The Italian DPA also opened a public consultation on its guidelines. So we can see different approaches, and authorities are really trying to understand the sector and Adtech in general. If we go to the next slide, please. So while the enforcement is accelerating, complaints are also piling up. So we have picked up a few complaints here. They're quite high profile and they usually target big tech. But it's not necessarily the case. As you can see, in the UK, they had almost 3,000 complaints last year. And it's obviously not from NGOs, at least not all of them. And here again, it's linked to what I was saying before. It's very easy for everyone, dissatisfied customers, your competitors, also to go on your website, check your cookie practices and complain. So it's true that we will see more and more complaints in the future, and especially this year. And if we go to the conclusion slide, then here I will give the floor back to Jo for some final comments. And yeah, in particular, if you can share your experience and how are you advising clients with this recent announcements and recent market trends, that would be very helpful. Thanks.
Yeah, so for the sake of time, I think I will keep it quite short. So from a marketing perspective, it's my opinion that advertisers will still need to advertise, and publishers, they will still need to monetize their audiences, right? So the changing privacy landscape is not going to bring an end to digital advertising. It will just change the way it is done. And I think in 2022, all players in the advertising industry, from advertisers to agencies to tech vendors and publishers, will need to re-evaluate their identity strategy and look for solutions that can solve their problems, and which may differ from one company to another. And here's some suggestions of alternatives or solutions that we discuss with clients. I will not maybe discuss all of them, but for instance, the privacy sandbox of Google is a series of APIs, right, which is designed to replace the processes currently managed by third-party cookies. And the goal of the privacy sandbox is to maintain targeted advertising and measurement for both advertisers and publishers, but to do it in a more privacy-friendly way. Instead of relying on cookies to store information, the information is stored in the browser. There are a lot of questions about this plan. Instead of storing information within cookies, it's done within the Chrome browser. So some say that it could potentially lead to a further strengthening of the gatekeeper position of Google Chrome. Another shift that we see is a shift towards contextual targeting. There's been a lot of talk in the programmatic industry about the revival of this type of targeting. This type of targeting is based on serving ads that are relevant to the other content on the screen. It's like you could compare it to serving ads for beer in a bar. So it's you go where your customers are. So we expect to see a lot more tools and options for contextual targeting in 2022 and beyond. I will not go into detail about the other solutions. I think that would bring us too far. Maybe we can spend the last 5 minutes looking to questions that we received.
Yeah, sure. Just a final remark from a legal perspective. I think it will be very interesting to see how the markets evolve and how new forms of tracking, or for instance, Google's privacy sandbox, does it fall under the current e-privacy directive? Will it be covered by the future e-privacy regulation? So there will be for sure give rise to some interesting debates, but then I'll give it back to Olivier for the questions.
Yes, well, thank you very much, 16, for this overview of the complex legal landscape. I think everyone has understood that it's not easy, and it's constantly evolving. So companies are dealing both with technological evolutions and also legal developments as well. So in the remaining minutes, so we have received a couple of questions. So I will take a few questions. The first question that I received was, what would you recommend as an appropriate peer to scan and review the cookies on the website in order to make sure that the cookie consent banner and policy are up to date? So essentially the question is, how frequently should we review the CMP and the cookie notice and banner, once a year or more often? So I think, yeah, there's no sort of a definitive period. Certainly, if you can do this on a regular basis, is good. If you're already doing this on a yearly basis, I would say that's certainly good. But I think it also depends on how often or how much things are changing on your web platform. So if you start adding new types of cookies within a short period of time, then probably you shouldn't wait for a full year to update your cookie consent platform. So I think, like anything with the GDPR, the continuous updating and auditing of your GDPR program and the different GDPR documentation that you have in place is something that you need to do on an ongoing basis. And so certainly, if there are changes that are made to the website, you shouldn't wait for too long to do that. Another question. What do you think about the intersection between the proposed e-privacy regulation and emerging Adtech technologies, such as the ones using emotional AI techniques or social media listening platforms? Now, this is maybe a question for Jo. I don't know if you want to say a few words on this. So on emotional AI techniques or social media listening platforms?
I'm afraid I don't really know how to answer that question. So I could definitely check one of our technical specialists and get back to this person, but I don't know how to answer it right now.
Okay,
yeah,
no problem.
Maybe a general comment on my side. The e-privacy directive and the future draft e-privacy regulation, they're all meant to be technology neutral. So in theory, they're not linked to a particular type of technology, and that's why the article on cookies is so general and it's difficult to interpret, because it doesn't refer to cookies and other type of trackers that we know. So I'm not familiar with this type of technology, but it could fall in the scope of the privacy regulation.
Thanks, 16. Another question, actually, which is directed for you, Jo. In your opinion, how would the sandbox be very different from the cookies, given that if you reach the browser of the user, you would still need to ask for consent? So,
yeah, I'm afraid that at this stage, a lot is still unknown within Google's privacy sandbox. So they have communicated the general outlines, but it's definitely still not clear for us also how this will work on a technical level. So I'm afraid that at this stage it's very difficult to also comment in detail about this. I think as we will move to the next months, this will become clearer. It's also obvious already that in Europe, advertisers won't be able to test out these privacy sandbox yet, but I think this will be clearer in the coming months.
great, thanks. Maybe time for one last question, and if we don't have time to answer all the questions, we'll try and do so by email. We have the names of the people who have kindly posted questions, but maybe a last one. Which cookie rules guidelines should we follow when a company is using the same website to promote its services around the EU? and is representing the company group as opposed to its national entities. So the idea being that it's one website that is representing the group and not necessarily different websites for the different entities. And in that case, should we take the stricter guideline if we are operating in different jurisdictions? Now, yeah, that's obviously a good question. I think this goes back to 16, your slide on the different approaches. Do you take a pan-European approach, a regional approach, or a country per country approach? I don't think there's a definitive answer to that, especially in the context of a pan-EU website. But I would say that from a pure legal and compliance perspective, certainly it's safer to take a stricter approach for a website that you are using to sell your products and services across the EU, because as 16 mentioned, if you go with the more a higher level approach, then you might not be complying with the guidelines in a specific country. But it also depends in which countries you are located, and so as 16 explained, I think it's important there to look at the guidance that has been adopted by the regulators in those countries, if such guidance exists, and then assess in terms of risk, whether the DPA has adopted some strict guidelines on cookies, or what is the approach of that particular regulator in terms of enforcement. So I think in summary, there's a number of factors that you need to take into consideration in order to assess how you're going to comply with these cookie rules. So I'm just conscious of time, that we've reached the hour, so unfortunately we won't be able to take any additional questions. But I would like to thank the speakers, 16 and Jo, very much for your great presentations and all of your explanations. And thank you to all of the participants for attending this webinar. As I said, it has been recorded. It will be broadcast on our YouTube channel, and so we will make it available to you. With that, thank you very much. Stay safe, and hope to hear from you soon. Have a very nice rest of the day. Bye-bye.
Thank you.